you don't mind. And so let's get into it. So I think Aija will begin, and she'll present us with an overall picture on blockchain and crypto disputes generally, why arbitration is important for these disputes, and how we can harness existing knowledge and resources to assist the blockchain crypto community with these disputes. Aija, please go ahead.
Thank you very much, Sean, and thank you for correctly pronouncing my name. That's never a guarantee, so I'm very happy about it. Welcome, everybody. Thank you so much for taking the time out of your busy week and right before the weekend to discuss crypto disputes with us. Very happy to be here because I think crypto and blockchain disputes are a very interesting new sort of section of the law that will result in both completely novel disputes coming about and also just an added layer of complexity on top of already existing disputes and situations that most people are aware of. And in my opinion, we as lawyers, we are service providers. So for us, the most important thing is that we can help our clients. We have the right skill set, we have the right knowledge base, that we are able to help clients in need to handle their disputes. And we also need to understand what the client wants, how they want it, and what type of result they're expecting. And in my experience for crypto communities, for people who are into crypto or who are very sort of into the blockchain space, it's a different type of client. It's not the usual sort of, director of a company or the Ministry of Justice of some country. It's most of the time, it's just, younger people, first of all, very innovative, want everything, quickly, just like that. They think of arbitration as like a legacy system, something that in a way that we regard national court jurisdiction. We think, oh, that's so old fashioned, that's so slow. They look at the terms for arbitration and the deadlines and how much time things will take, and they're like, this is super slow and super inefficient. So I think it's also up to us as service providers to take care of that and to find the best way of catering to those communities. So today I'm just gonna go through an overview of the types of disputes that can arise in the crypto and the blockchain space. And so the first one, and maybe the most obvious one, is disputes relating to smart contracts. So smart contracts are obviously coded contracts. You have an agreement, either you already have a written agreement and a signed agreement on the side, and then you get that agreement, or you communicate the agreement of the parties to a programmer who then types up code, and everything is executed automatically. The way crypto can get into that is that if the payment of that contract is in crypto, you already have the crypto locked in on a specific blockchain. And when an arbitrator takes a decision, that specific crypto is released into the public wallet of the party who is winning the arbitration. So that is a very specific blockchain dispute. And you would think that because it's automatic and everything gets executed automatically, there'd be no issues and no need for lawyers to intervene. But unfortunately, or to the contrary, good for us, that is not the case. And you can have disputes relating to those smart contracts as well. So first of all, you can have instances where the code is incorrect. For instance, the code does not reflect what the parties wanted it to reflect. Smart contracts cannot be altered. The only thing you can do is delete them from the blockchain and then substitute them with a new contract. You could possibly envisage cases against the programmer who's made that mistake with coding errors. Then you may obviously have sort of classic issues of misrepresentation or fraud, illegality, or issues of capacity of entering into a smart contract. And these types of contracts may not be extremely common now, but they can prove very helpful in, for instance, construction arbitration, where there's a lot of deadlines and a lot of money flowing back and forth. And it could be very, very helpful to implement smart contracts in that context. And obviously, since we all know, because almost everybody's worked on a construction arbitration, and I think that's one of the most lucrative in terms of the amount of cases that you get. I think the moment that smart contracts get widely implemented in construction in general, is going to generate a lot of cases for arbitration attorneys. And then another category of disputes that I think is actually very prevalent, but maybe we don't hear about them but most of them are probably confidential, are consumer and user disputes. So if you look on the blockchain and especially the crypto side, there's a lot of actors. For instance, if you wanna purchase crypto, you'll have to go through a trading platform most likely, or some sort of seller. Then you always need a crypto wallet to hold your crypto and your NFTs if you're buying NFTs. You're purchasing NFTs on a platform such as OpenSea. You may be trading, you may be buying tokens, you may be trading futures. There's a lot of different what are actually financial instruments, but they're sort of not quite categorized in that way right now. But there's a lot of service providers that enable the crypto community to do what they do. And most of these companies will have arbitration clauses. For example, MetaMask has AAA, Coinbase has AAA. There's a lot of jams right now. I think jams is the most prevalent one that I've seen. I've seen an ad hoc arbitration clause. I've also seen a couple of ICC clauses, and there is actually a publicly known, not mine, ICC case currently underway, and I think it's in Paris, if I'm not mistaken. And there's obviously Hong Kong. I've been a bit involved on that side. I've also seen there's a company called Deribit, whose terms of use provide for the jurisdiction of Panamanian courts and the application of Panamanian law. So I think the inclusion of these dispute resolution clauses that include arbitration are kind of, on the one hand, an attempt to keep people at bay from litigating, and on the other hand, it's the companies realizing that they're definitely better off if these cases go to an arbitrator as opposed to a national court. Because the issue is that even we as private practitioners, it takes us time to understand all the issues. It takes us time to read all the decisions. And even just from a technological perspective, even if you don't have to be a super expert in these issues, you have to sort of be able to orientate yourself in what's happening. And as you can imagine, most state courts do not have that capacity to do that. So it's a lot easier if a dispute comes to an arbitrator who's already, he knows, or she knows what a crypto wallet is, what a cryptocurrency is, how it functions, as opposed to it going to a national court judge and her looking at it and just saying, what is this? When am I going to have time for this? How is this going to work? So there's a big interest, I think, in these companies in putting these clauses in. And then in terms of what kind of disputes can arise, there can be a variety. So for me, the main thing is consumer type disputes, because obviously when you have a relationship with as a crypto user, you have a relationship with one of these service providers, you are a consumer and you have signed a contract with them through the terms of use, and they provide you with a certain service. Now, there are certain instances where that service is not going to be up to snuff, where there's going to be things going wrong. For instance, as Jean mentioned, I've been involved in a case where traders have claimed wrongdoing on behalf of Binance, who is one of the world's, it's the world's largest trading platform. And that relates to a massive, let's call it a crash for a better word, of the platform a little over a year ago, where traders were just not able to close their positions. Everything was frozen. People were liquidated, because obviously when you're trading, you kind of like the platform is kind of like a casino, but they also know your cards because they know what your liquidation red line is. So the moment that goes below, all of your funds get liquidated. So a lot of people lost a lot of money. And this is not the first type of the first one of these types of cases. There have been others, and I do see quite a bit of potential for new cases coming up, especially in the wake of the Terra Luna crash that started in March. So Terra Luna is, or was, I think is more appropriate to say right now, an algorithmic stablecoin that was it seemed so successful. At some point, somebody was trying to convince me to buy it, and they were, oh, too bad, you missed out on it. It was like a little low 2 weeks ago. It was at $80. Now it's at 110. Maybe wait 2 more weeks, it's going to go down. And I'm pretty happy I didn't buy it, because it crashed stupendously. It went from sort of $80. I think the high was 120. And then it just rapidly crashed to sort of 10 cents. And then in the end, now it's worthless. So, and there's a lot of these crashes. There's a lot of projects that get started, get financing, and then just end up crashing and burning. For instance, Terra Luna, I think it cost the market sort of $45 billion in lost financing, which is, when you think about it, enormous. And obviously, a lot of people had already invested. So there's no user agreement for Terra Luna, but I can see that kind of situation leading to a case. And then, because right now it's a bear market, so things are really slow, Bitcoin is down, literally every cryptocurrency is down. There's been other issues with other companies, for instance, Celsius, and Celsius is a trading platform that also guarantees revenue by staking your token. So if you stake cryptocurrency with them, if you have Celsius wallet, they say that you earn interest, which they cannot legally call interest because their lawyers have told them not to call it interest, they call it rewards. I know this because I had a couple of months ago, I attended Paris Blockchain Week Summit, and I actually met the CEO, and I talked to somebody who knew a bit about the legal department. And the moment I told them I'm a lawyer, they're like, "What do you want from us?" It's like, nothing. I come in peace. I come in absolute peace. So, and they, because of the crash and because they're having liquidity difficulties, because a lot of people, once they feel that crypto is unstable or things are going to go south, you either, what you say in crypto is hodl, hold on to dear life, which means that you keep your crypto with you and you don't sell it, or they sell it frantically, which then tanks the value of the crypto, which then exacerbates the problem. So a couple of weeks ago, Celsius actually sent their users an email saying, so sorry guys, we're experiencing issues, so no more withdrawals and no more transfers, which kind of completely defeats the purpose of having your crypto in their wallets. And Celsius does have a AAA clause, and I wouldn't be surprised if cases would come out of that situation. And as I said, I'm absolutely sure that there have been a lot of crypto-related cases out there. It's just that we don't always know about them. And I think cases that are sort of a little bit more high profile, like the ICC, Hong Kong, maybe Singapore, they tend to, somehow information tends to leak a little bit. I think the situation is different when it's jams or if it's the AAA, and usually the cases are smaller. But I do smell a lot of potential there, and I think it would be amazing if the arbitration community can step in on behalf of those clients, or even on behalf of these companies, in order to contribute to the resolution of these types of disputes. And one of the things that I want to point out is that a lot of times these crypto-related disputes with these platforms, they're not going to be for an insane amount of money. It's not going to, most of the time it's not for sort of 100 million, even 10, 20. It'll be smaller sums of money, for instance, I don't know, 10,000, 20,000, 30. And I think it's also important to acknowledge that these people, these crypto users who lose even that amount of money, they need to somehow have access to justice. And a lot of times that is really not possible. For instance, nobody's going to start an ICC arbitration or Hong Kong arbitration for $20,000. It's just ridiculous because it's too expensive. But at the same time, I do really feel for people who can't do anything. So I think it'll be up to the crypto community and these platforms of finding a way to efficiently deal with these smaller claims. And I think it would be in their absolute interest to do so. Now, moving on to another type of dispute that will arise, it's just regular run-of-the-mill commercial disputes with a crypto or blockchain twist. For instance, crypto or NFTs could be the object of a contract. It could be the payment method of a contract. There could be instances where crypto or crypto-related assets are used as collateral. There could just be shareholders agreements that are somehow related to the crypto world. And that is also something that we need to take into consideration. For instance, it could be a shareholders agreement about a crypto company, and the payments are in different wallets. Investments were supposed to flow into one crypto wallet, didn't flow into that one, flows into another one. And we as lawyers, we should be able to sort of get to the bottom of it and propose efficient solutions to our clients. And it will also bring up issues of what jurisdiction to pick as the seat of arbitration. For example, right now in the UK, if you have some sort of commercial contract where the payment is in crypto, and instead of fiat, instead of government issued money, you want to recover the crypto, it's basically, you have to ask for specific performance. It's kind of the same thing as selling your house for like 3 cows and wanting those specific cows afterwards. So there's a lot of issues with that. There's not that much case law. I think things are evolving. There was recently a case that that concluded that an NFT was a digital asset, it was digital property. But there's a lot of sort of blind spots that we will have to deal with at some point. And another thing for these commercial disputes with a crypto related aspect, I think it'll also be an issue of picking the right arbitration rules. Because obviously, for instance, if you need the tribunal to order specific performance, it's obviously a lot more helpful if the administrative rules that you're applying already provide for that opportunity. Or for instance, if you need preliminary measures, let's imagine a situation where 2 parties are in a dispute over crypto in a specific wallet, and only one of them has access to the wallet, the other one wants access. Can a tribunal order, disclosure of the password? Or for instance, if there is a massive crypto crash like right now, could one party compel the other to sort of save that money, to safeguard it by converting it into government issued money? Could an arbitral tribunal ask for that as well? Never been done, nobody knows, but I think it's going to happen at some point. And then just to end this on a shorter note and kind of really out there, it's also investment treaty disputes can come into play with crypto. For example, a lot of BITs just have in the definition of investment is just like a massive laundry list of anything. It's sort of any asset, any claim to money. For me, it's not very sort of out there to argue that a cryptocurrency could potentially be that claim to money. There's also governments that have issued national crypto. So for instance, to me, that would be more like a government bond. You could also claim that that's an investment. And then there's also obviously more specific things like crypto mining and crypto mining farms. But I think we're going to face a lot of these issues now, especially with the crash and especially with the onset of regulation, because every time a new asset is regulated, people want it more. People feel more comfortable with it. People are less afraid. And I do think with the onset of regulation, you're going to have more and more people transacting in these assets. Because right now, I think crypto has been adopted only by about sort of 3% of the general population. So it's still very new, although obviously all of us who missed out on Bitcoin back in the day, we feel like we're really late to the game. But the reality is that we're really not. And then the other issues that will follow will be enforcement, for instance, seizure. How can you seize these assets? What can you do? Damages will be a massive issue as well, especially for these platform crashes, because there's a lot of moving elements. There's a lot of moving parts. It's not something that we are usually used to doing, and that damages experts are used to doing. So I think there's going to be a lot of issues and a lot of potential cases. So thanks very much, Sean. I'll hand it over to Mihaela.
Thank you. I think some fascinating points made, and I'm sure there'll be questions raised at the end about it. And it's a great segue into Mihaela's section. So Mihaela will provide us with an overview of the crypto disputes currently being litigated in national courts, and cover briefly some of the specificities of these disputes that involve crypto assets. Mihaela.
Thank you. Well, it comes to me now to cover the rivals of the arbitration, which are the courts of law. And I'm going to touch briefly on the application that has been decided by the courts, what were the issues and what were the challenges. Of course, this will be a very brief presentation because contrary to what was a couple of years ago, where we couldn't find any decisions on crypto disputes, now there are actually quite a few. So I will just make some brief comments about each of them. Talking about disputes, the crypto disputes and how much they have evolved, one of the US law firm Morrison Cohen did a recent study to see how many more disputes have arisen recently, and they just noted in a recent report that this year, only in the US, there were around 200 crypto disputes just launched, which is like 50% more than it was in 2020. And as Aija mentioned, the most common type of disputes involving crypto cover fraud cases, misrepresentation, consumer disputes, or breach of contract or smart contract. I will focus a bit on exploring what type of applications were made in support of these claims. And it's important to highlight that although there have been quite a considerable number of court decisions involving crypto, most of these decisions are interlocutory decisions, meaning that the court did not enter into the merits of the case, but rather they conducted a sort of a general prima facie analysis to see if the applicant has a right to pursue. So in most of the cases, the threshold is this a good arguable case? The most common application to the court of law has been in relation to asset recovery, worldwide freezing orders, and disclosure orders against third parties. So when it comes to asset recovery, this is usually a consequence of fraud or ransom attack, where the crypto holder just realized that she or he was not that rich as they expected to be, and they became almost bankrupt overnight. And this type of disputes raise the question, do they actually have a property? And I will discuss this a bit later. But from what I noticed, the majority of the courts, and I'm referring here to the common law courts and especially to the UK court, have been quite supportive in terms of granting this type of applications. And I'm referring here to the AA versus Person Unknown in 2019 case in the High Court of Justice. Same, the court in Hong Kong had a similar approach and granted asset recovery in Nico Constantine versus Steve John Paul Dan, and similar cases have been recorded in Singapore in the CLM versus CLN case. Another very useful tool is to obtain a worldwide freezing order. And this is probably the most sought in the UK, because UK has been quite supportive of this type of applications, and they try to find jurisdiction whenever there is a connection with the UK. And they granted us application in XY person versus person unknown. You hear a lot about person unknown just because it's just sometimes very difficult to identify who are the perpetrators. And I'm going to touch about this a bit later. And another application actually concerns the exchange platform, the crypto exchange platforms. And in this type of application, the account holder actually asked for the court to order the exchange platform to seize the crypto and whoever hands are, or to provide specific information. And probably this is one of the advantage that litigation has, if you were to compare it to arbitration, where arbitrators are limited to only take decision in regard to those who signed the arbitration agreement. And now that we have an overview of the main applications, I will talk about the type of legal issues that appeared. And one of the main challenges faced by the courts when dealing with a crypto dispute is to identify to what extent the established legal concepts such as property, trust, or fiduciary duties, upon which Eli will talk a bit later, are applicable to this type of novel legal relationship generated by crypto. And answering this question is particularly important to identify what remedies can the crypto holder or the alleged crypto holder can claim from the court. For example, to be able to ask for a proprietary injunction, it's necessary first to establish to pass the threshold that the asset is a property. So it's very important to go through the analysis of these legal issues. And so far, luckily, I will say that the courts of law have been quite supportive in terms of recognizing crypto as a property. Even if they made this analysis, as I said, just a preliminary as a preliminary analysis, they decided that there isn't anything that will prevent the court to arrive to a different conclusion. So they said that a crypto is a definable, identifiable asset and has some degree of permanence, and therefore that qualifies as a property. And here we have actually a huge number of decisions, and I would just refer to only a few. One of them is Yon Science versus Person Unknown. Another one is Wang versus Darby. And we have another one from the Shanghai First Court, which is Li and Bu versus Yan. And all these courts have decided around the world that crypto has the characteristics of a property and can be therefore can be the object of an application for a property injunction. The next important question to answer is whether the relationship between the account holder and the platform where the crypto is exchanged can qualify as a trust relationship. And this question is very important because based on the answer, you can see exactly what type of rights is the account holder entitled to. So the court look at the parties' objective intentions when they enter the transaction to decide if the relationship can qualify as a trust or not. And even if they use in their exchange messages words like my property or yours, that was not considered enough to decide that the account holder has the crypto. And the court, when deciding if there's a trust relationship, looked at three issues. One, whether there was a certain intention between the party to establish a trust, whether there's a certainty in terms of subject matter, meaning can we identify the underlying asset, and whether there people involved can be identified. In case the transaction involves a transfer of property, sometimes in the terms of conditions of the platforms, they will mention that the account holder will actually give the crypto to the platform who will hold it. And if this transaction involves a buyback or it's a clear transfer of ownership, therefore there will be no trust. So in B2B versus coin in the Singapore court, the court held that the relation between the account holder qualifies a trust, mainly because the assets were held on the platform separately than the assets of the trading platform. So it was a clear defined line between the assets of the account holder and the assets of the platform. To conclude on this point, whether or not a specific legal remedy exists in terms of is the account holder entitled to a worldwide freezing order, or is it entitled to a property injunction? It very much depends on the structure of the agreement of the parties and not necessarily on the taken nature of the underlying asset. So basically, the same legal concept will apply even if this is a new technology. And I have also touched a bit on the problem of jurisdiction, and I mentioned before quite a lot of time X versus person unknown, and this raises actually a jurisdictional issue in terms of jurisdiction ratione personae. And to overcome these issues, the English court have actually granted, in many cases, freezing orders against persons who are unknown and who are also outside the jurisdiction of the UK, only if the applicant managed to establish that there's a serious issue to be tried, as in they really have a case. Second, if they have a good arguable case, it's not enough to have, let's say, a simple claim. You also need to have underlying evidence for it. And third, whether the UK is the appropriate forum to trial that dispute. And meaning what are the connection between the UK and the respective dispute. And this is also a point that touches upon the court's jurisdiction in terms of ratione materia, because if the assets are not related to UK, then for sure the court will be difficult for the court to establish a connection and therefore accept the application. And a couple of factors that actually influence the courts to take a positive approach and grant the orders were if the underlying assets were connected to UK, if the applicant has their jurisdiction in the UK, or if the place of damages was the UK. This kind of, issues and hurdles are, let's say, a bit easier when it comes to talk about evidentiary and evidentiary documents, because at least at the European level, there's a regulation that recognizes the admissibility of blockchain stored evidence, and that's the regulation 910 from 2014, which under certain condition gives the data recording on blockchain a presumption of accuracy and integrity, which makes the burden of proof a bit easier for the applicants. But the downside of administering evidence in blockchain procedures is having to deal with the technical issues that the applicant might face in terms of bringing that evidence to the court, as the court might not have the right infrastructure to analyze it and assess it. And assuming now that the applicant passes all these jurisdictional evidentiary hurdles, as I said, they might also face this technical issue that I mentioned, and at the same time, they might not have the support of the trading platform, who might deny to provide the information requested and say that it's not technically possible. And this actually happened in a recent scenario where the Ontario Supreme Court ordered the trading platform to freeze all the account holders of those who were involved in the anti-COVID measures restrictions. And the managing platform sent an information to the court saying that they do not collect the information of the users, they cannot change the data, and they cannot they do not have any sort of knowledge of the existence and nature of the users, and therefore there's nothing that they can do from a technical point of view. I'm not sure if this was actually the real reason, or if they just wanted to support the users and not enforce the court decision, but probably we should take into account that at a technical level, it might not be always possible to trace this asset. And I will briefly conclude that in certain circumstances, even if all these hurdles are passed, the court might still refuse to grant any application in case there are any question in terms of money laundering or economic sanctions in countries where using crypto is banned, and therefore the applicant might still not have a recourse to the court, and who knows, maybe arbitration is an answer for them. That'll be all on my end. I will let Ellie talk more in detail about fiduciary duties.
Thank you, Mihaela. And so, yes, indeed, Ellie, last but certainly no means least, I think you're going to look specifically at the recent UK High Court judgment in Tulip Trading Limited versus Bitcoin Association, and provide a bit of a flavor about how crypto disputes prevent novel and interesting substantive challenges to judges and to counsel. So please, Ellie.
Hi, everyone. Thank you, Sean. Thank you, Aija. Thank you, Mihaela. It was very interesting to listen to you. So as Sean explained, my presentation will be more on a specific case, but as I was listening to Aija and Mihaela, you will hear about some of the issues or the principles that they raised. So before I jump actually into tulip trading, by way of introduction, I did want to touch upon two other cases, just because of this sort of leitmotif that we've seen until now, and that is also present in my presentation, of the applicable traditional law and whether it is suitable really to these novel situations, these new realities that we see. And first of all, I will touch upon a case, it's a US case where a criminal law, as we know, it was applied to a situation which occurred at OpenSea. So for those of you who are not aware, a former OpenSea product manager who was responsible for choosing which NFT collections will be put on the front page of OpenSea, so this NFT trading platform, was basically buying these NFTs from an anonymous wallet through a different account at OpenSea prior to them going on the front page and their value skyrocketing. And then once they increased in value, he would go and resell them for 2 to 5 times the profit, so 2 to 5 times the value that he bought them for. And he has recently been charged with wire fraud and money laundering, which is quite interesting. So for now, these are accusations. He hasn't been found guilty. But the reason why I'm talking about this is because the US attorney said the following: NFTs might be new, but this type of criminal scheme is not. So the point I'm trying to make with this case, just by way of introduction, is that there are certainly instances where we can breach the law in quite the same way, whether we act online or offline, or in the traditional way, or whether we are in these novel situations. And so trading at a stock market could possibly be analogous to trading on the blockchain and the criminal law applying. The second case also shows that you can apply traditional law to these novel situations if you're a little bit creative. And a big thanks actually to a friend of mine from Lejniece who made me aware of this case recently, and it's very interesting. It also took place in the US, and there has recently been a temporary restraining order which was served on an anonymous defendant as an NFT. So basically what the court did, so it was the New York court, they created the order on chain, and then they airdropped it into the wallet of this anonymous person, which I find very interesting, because ultimately you apply the principles as we know them if you just find this creative way of doing it. Now, the context for this was the hacking of the LCX exchange, which occurred in January of this year. And following this hack, the law enforcement agencies carried out basically an international investigation, and then they identified the funds and also the wallet that was involved in this hack. And so despite not having the identity, and this goes to also what Mihaela was saying, often we cannot identify the person, but despite not having the identity of this defendant, having the wallet was enough to issue this order. So the takeaway from the second case that serves as introduction is that sometimes you can apply the traditional principles if you're a little bit creative. And it is also, in my opinion, an important reminder that as lawyers in this evolving world, it is very important that we have the technical understanding. I am not sure how many, I mean, this is definitely not something I would have thought about. You do need this technical knowledge to sort of be able to be creative. So that was for the introduction. I will now move into tulip trading. And the reason why I mentioned these two cases was really just to make this contrast with this application of traditional law, traditional principles to the novel situations, because this is not really something that works in tulip trading. So I will go over the case. First of all, the background. So there was an alleged hack which affected a company called Tulip Trading, or more specifically, its CEO, Dr. Wright. And basically, due to the hack, Dr. Wright was unable to access wallets, which contained a few $1 billion worth of crypto assets. The reason for this was because during the hack, his private keys were deleted. So just by way of a parenthesis, in case this could be of use to someone in the audience, each digital asset is basically represented by a pair of data. You have the public information, and then you have this private key. So the public information, obviously, is which you can see publicly the value, the transaction history, for example. But the public key is what gives you the control over the asset. And so that is what was lost in the present case. So they can still see that the assets have not been moved, but because they don't have this private key, they cannot do anything. And so since these assets are held within certain networks, the idea of Tulip Trading as a company was to make these networks and or their core developers accountable, and request that they counter the effects of the hack. And so Tulip Trading is basically requesting that the networks and or the core developers create and release a software update patch. And what they seek from this patch is either the transfer of the assets that they no longer have control of into a new wallet, or as an alternative, that they issue a new private key so that they can again access these assets. And the basis for these claims is the English law of fiduciary duty, which Mihaela touched upon, and the duty of care. Now, I do recommend that you read the whole decision, because I will not have time to go into a lot of details, and the reasoning is very, very interesting. But I will look briefly at both of these duties and what the reasoning of the court was. So first, if we look at the fiduciary duty, basically Tulip Trading recognizes that there is not a typical fiduciary duty. So that would be usually your client-attorney relationship or trustee beneficiary. So they do recognize that there is no fiduciary duty in the traditional sense, but they say that because of the particularities of this case and circumstances, this sort of justifies the imposition of fiduciary duty here. And they justify this by 2 points. First, because there is a significant power imbalance, because according to Tulip Trading, the defendants have complete control. They could issue this patch and run this patch and update the software, whereas the users have no control at all. The only thing they can do is to use their private keys, which obviously if they lose, there is nothing else for them to do. So the significant power imbalance is 1 point. And the second point is that the users entrusted the networks or the core developers with the care of their property. So these are the 2 points that would, according to Tulip Trading, justify a fiduciary duty in this case. Now, the court explains that, sure, these are features of fiduciary duties, but they are not defining characteristics and they are not a sufficient condition. And then they go on to explaining, and this is also what Mihaela explained with respect to the trust relationship, but they go on to explain that fiduciary must have undertaken the duty to act solely in the interest of the principal. But here we have users, which are an anonymous and fluctuating class. We also have developers, which are a fluctuating class, and basically the court says that it would not make sense to impose this duty on the developers, because it would ultimately mean that they have to remain as developers and then run any updates that are in the interests of users. So the court looks also at the consequences that imposing such duty would have, which is very interesting. What is also problematic, and where the Tulip Trading reasoning was a little confusing, was that they seek relief that might be to the detriment of other users. So they seek this patch, this update to the software for their benefit, but it is not clear whether it could affect negatively other users. So this is also something that the court points out. Now, moving on to the duty of care in the interest of time, there is a little bit of nuance. So basically what Tulip Trading says is that the violation of the duty of care would stem from the fact that the initial software did not include or does not include any means for the users to recover their private keys or any safeguards against wrongdoings. Again, detailed reasoning, very interesting, but the bottom line is that the general law principle is that there is no duty of care to prevent third parties causing loss or damage. And here the hack arguably comes from a third party. There are exceptions to this general principle, but where the damage is only economical, like in this case, there has to be a special relationship. And so here the court refers back to its analysis of the fiduciary duty. And since it established there that there is no special relationship, there is also, there is still no special relationship that would warrant the application. What is interesting as a side note is that the court mentions this hypothetical scenario where it says that had the developers taken a positive action, so had they ran an update, for example, that was detrimental to the users, then there could be some kind of duty, but they don't really define it. And it's very different from our case. But I found it an interesting side note that case might be called under the traditional law principles. So all in all, the court says that there is no basis for the claim under existing law, but it does leave the door open, again, which is interesting. And it says that there might be future developments, that there might be future legal remedies, actions, and it refers also to the Law Commission's project on digital assets. And just to briefly conclude, so that we do have maybe some time for questions, if there are any. I do not find the decision that surprising if you look at the definition of the duties under English law. But then obviously the bigger question is whether there is insufficient protection of the users of these platforms. And this is an issue that has been identified in the Crypto Ethics Task Force final report, where they say that some of the risks to consumers are obviously the loss or theft of private keys. And then, from this question stems another question of whether there should be consumer protection as we know it. At some point in the decision, there is quite an interesting passage on the fact that basically the users can store their private keys in a way that prevents loss or theft. And so there is sort of this shifting of responsibility, which might be interesting to explore. But ultimately, how this is dealt with remains to be seen. And it obviously also remains to be seen how it's dealt with under English law or by other countries. And this is my last point, and it has been obviously touched upon by my co-speakers, but this will likely give rise to different solutions, and from that will stem issues that we very well know, all of us, such as forum shopping and so on. And I am happy to move into the Q&A if anyone has questions.
Thank you very much, Ellie. Yes, as Ellie said, please, if any of you wish to, you can absolutely type your questions in the chat if you don't wish to unmute, but please do go ahead and unmute and ask any questions you may have.
I'm just gonna, I know I'm a co-panelist, but I have a comment on what Mihaela said about sometimes courts being the right way to go. And it's true that crypto companies, I think, have been pretty okay with, like, on the one hand side, that crypto is very sort of decentralized. Everybody likes that it's not controlled by the government, etc. But I think in the past 6 months, we've seen that they are actually pretty cooperative when it comes to certain things, especially when the Russia sanctions came about after the Ukraine war was started. A lot of crypto companies would be, they enacted the sanctions. They were not, they didn't say, hey, I'm outside of this government business. I don't care. I'm not going to do it. Like they did apply those sanctions because they are companies incorporated within certain jurisdictions that implemented those sanctions. And although like everybody made clear that they didn't like the fact that they may have to block, for instance, Russian wallets, crypto platforms that are registered in the EU, they did put limits on, even Binance, they did put limits up to, I think it was a third or the fourth package of the EU sanctions, where they said that crypto wallets will be limited to 10,000 euros for Russian nationals, and they did implement those companies. And I know that there have been instances. I know people who have managed to seize wallets, to put a freeze on a wallet through courts, because obviously the money is in the wallet managed by a platform. So that's the way you go about it. And it's true that while, crypto was always supposed to be a little bit out there, they do cooperate, because I think the companies are not interested in having, too much trouble on their hands. And it's the same thing with the consumer protection that Elisabeth talked about. My opinion has always been like, it would be so much better for these guys to say, hey, let's figure out a system that works for us, where we just give like a tiny bit of pie away in favor of our users, of the regulator, whomever, and let's come up with a system that has consumer protection, as opposed to what's happening now, where people are kind of partying and drinking and not thinking about the hangover the next day. Because at the end of the day, I don't think crypto is going to go anywhere, and I don't think regulation is suddenly going to disappear. Regulators will just say, hey, you know what, it's actually not that interesting, or let's not do anything about it. So I think it would be in the interest of all these companies to actually participate in the process and come up with something alongside governments, and just wait for governments to come in and like put a paw down on them and take all of the pie.
I think they understand what is at stake. So if they don't collaborate, they probably will not have a future in their business. So they take a quite informed approach on this, just to be sure that they will be able to remain in the market.
Thank you both. Yes, if anybody from the audience wishes to ask a question, please go ahead. I don't see anyone unmuting, and I have a brief kind of forward-looking question, and I suppose it's to all three of you, and feel free to answer or not. But I just wonder, are we going to have to see wholesale amendments to different pieces of legislation to deal with these kind of technical or just conceptual issues that crypto and blockchain assets will raise? I mean, we see it through the UK Law Commission report. I think, yes, a lot of contract law can be taken into smart contracts, but what will we do when the court decides something, orders something, and then unfortunately from a technical point of view, it won't be able to be implemented, or it will be some kind of legal fiction that a court will try and get around an issue that they really need codified law to rely upon. So I wonder, it's an open question to the three of you. Feel free to answer or not.
Yeah, I think that things will happen as they usually do, where you'd have sort of a piecemeal approach by, a case here, a case there. And at the point where there's going to be little cases everywhere, the more forward-looking jurisdictions will come up with some sort of more global regulation. I think the issue is as well that it's hard to, when you have a new class of assets, or like new instruments, or anything, like crypto can represent a lot of things. I think it's also a little dangerous to immediately come up with something very comprehensive, because it's the same. It's sometimes you get disputes about things that, not necessarily crypto. You'll get some crazy shareholders dispute, or some, contractual issue with fraud, and you never in your wildest dreams or nightmares would you have imagined such a scenario. So I think what's going to happen is, we're going to have, I think, more than a couple of years of, courts here and there deciding. Then, either the EU or individual countries will have commissions who will start thinking about this. And then there's going to be another couple of years, researchers and cases are going to go forward. And then maybe at some point there's going to be something more specific. That's my opinion. I see Mihaela nodding. What do you think?
I totally agree. And I think what's happening now looks very similar to what happened during the financial crisis, with the financial derivatives and all those products that we could not read and understand how they work. And at that moment, all the financial stakers were saying, well, we don't need regulation because our market will self-regulate. But then the parliaments around the world just realized that this is becoming a big issue, and they started to regulate. I think this is what is happening with crypto. At the beginning, everyone is just looking at it from the side and just watching it, but when they realize what is at stake and how much money are involved and how many people can be affected by fraud and all this hacking attacks, eventually the states, they will step in and take measures. And I think in Europe, at least, I've seen quite a few initiatives in legislating smart contracts. I think Italy has a law on this, recognizing blockchain and smart contracts, and I think as soon as we see a few leading countries doing that, the rest will just follow with the same steps.
Great. So I think we've run 2 minutes over time, and apologies for that, but it was an absolutely great session. Thank you again to all three of our esteemed panelists. And please, if you in the audience wish to attend other ArbTech events, please follow our LinkedIn page and our Twitter page, and you'll see all of our updates there. And I just want to say have a great evening to everybody, and see you again later in the year. Thank you.
Thank you, Sean. Thank you, Ellie.
everyone.
Thank you, Aija.
Bye-bye.
Bye.
Bye-bye.